Hello everyone and welcome. My name is Ylva Hartman and I work for the Swedish Foundation for Human Rights. We are the Swedish representative of the international campaign GQUAL, gender parity on international posts. We have the great honor to have Mrs. Navi Pillay with us today to talk about this campaign and gender equality in international tribunals and on international posts. Just an introduction to Navi Pillay. You are the former United Nations High Commissioner for Human Rights. You are from South Africa and was the first woman to start a law practice in your home province of Natal in 1967. You have acted as a defense attorney for anti-apartheid activists, exposing torture and helping establish key rights for prisoners on Robben Island. And after the end of apartheid, you were appointed as judge on the South African High Court, and you were also later elected to sit as a judge in the International Criminal Tribunal for Rwanda, and was also this court's president. And you were also a judge at the International Criminal Court. And heavy CV there. I'm just going to mention a few words on the GQUAL campaign. We are working on enhancing women's participation in international organizations and tribunals, because women are underrepresented in virtually all international organizations and international tribunals. Just a few figures also, just to show this underrepresentation. Only 17% of the judges in international courts are women, and one of the worst examples here is the International Court of Justice, also called the World Court. 3 out of 15 judges are women there today, and since the establishment of the court, 106 judges have sat on the bench, and only 4 of them have been women. That is 3.77% in total. And at the International Tribunal for the Law of the Sea, only 1 judge of 21 judges are a woman. And this is crucial to have the women's representation also in these organs, because these are the organs that are responsible for elaborating and respecting human rights and public international law in general. So my first question to you is what difference does it make to have women judges in the tribunal, and why are diversity and adequate representation of women relevant for justice?
Well, is this on? All right, so the first question, as you've heard, is why we need women on the bench and what's their added value. I can't tell you how many times I'm asked that question. I say you shouldn't be asking that question. The question should be, why aren't women on the bench? Why are we excluded from the bench? So that should be the starting point. However, I can answer the question about the contributions that women judges make to the bench. So let's first look at the criteria that the Rome Statute has for the International Criminal Court. It says the representation of the principal legal systems of the world. So you have to have in an international court common law and civil law systems. The equitable geographical representation. So if it's a world court, you know, all countries should have a turn to send their representatives in, and a fair representation of female and male judges. States parties shall also take into account the need to include judges with legal expertise on specific issues, including but not limited to violence against women and children. So I think that's very important criteria. for the election of judges, and of course it's not being observed. When the International Criminal Court started, we were 8 women, so we were just 8 out of 18, which was an excellent start. But gradually, as countries are voting in new judges, as judges retire, I'm afraid the GQUAL campaign is right. We're going to lose the number of women even on the International Criminal Court. So I think you asked the value. Before I do that, what is fundamentally at stake when we're talking about women on the bench? Is it a matter of ensuring that in a democratic society, women have equal opportunities to become judges? Is that what we're talking about? Or should an effort to ensure that justice delivered is not gender-biased justice? Is that our concern? Or part of a more comprehensive attempt to reshape a public culture by destabilizing traditional roles? And we all know that this is a big struggle. For people to appoint women judges, they're so traditionally used to having male judges. They don't look outside the club of males? Or is it the realization of the right to equality and an end of exclusion, which is a position that I've adopted? I first want to know, why aren't women there? And then you get the answer, there's not enough qualified women. So let me tell you that this Secretary General of the United Nations has put in 13 USGs, that's the leaders just below him, including UN security. He's put in women where, for the last 60 years, they had been occupied by men. And the way he did it is, when the selection committee handed him a list, if it was only men, he threw it back. And he said, I want women candidates in there. So when things look impossible, if you take assertive action, not affirmative action, but assertive action to deliver on the principle of equality, it can happen. I can tell you the value that women bring in is that they have a life experience of what it's like to be a woman. They can't walk freely on the street at night, for instance, which is not a fear of men. They take all these things for granted. But women have to be cautious. Why? Because they're afraid of men. The violence comes from men. So they enrich the bench by coming in with their own experience and understanding. When I started off as a lawyer, as a young lawyer, straight from university, I thought that the women who came before me and cried and wept were very weak. I thought, just I'm strong, you should be the same. Until I heard them say, we came to you because you're a woman and you will understand a woman's perspective. So all the lessons I have learned in life are from other women. So whether they need not be university graduates, it could be your own mother who's never been to school. You learn lessons from them on the value that they could bring. In the international tribunals, certainly women, wherever there was a bench of 3 judges in which there was a woman judge or 2 women judges, that panel delivered verdicts on rape and sexual violence in conflict. And where it was a male-only bench, they did not touch the issue of rape and sexual violence. Some of the judges, the male judges, explained to me, and this was in the Rwanda genocide situation, they said, oh, okay, these women were raped, but they were killed anyway, so let's just deal with the killing. That's a serious crime. And so they chose not to deal with the serious crime of rape because they said death followed anyway, we'll deal with killing. So you see a real lack of understanding. And of course, as you know, judges usually ask a woman who had been a victim of domestic violence and who had hit back, sometimes killing the battering's man. Judges say, yes, but you picked up a weapon, so you had time to think, and formed an intention to kill this person. And they sentenced women to huge terms of imprisonment because they retaliated against the batterers. And the judges interpreted that moment where she went to fetch a weapon as indicating an intention to violence. So gradually that has been addressed. We got men to understand that women are physically weak, that's a factor. They can't hit back. Their punches and slaps are going to make no difference. And this is why they're forced to go and look for a weapon. So it doesn't necessarily mean an intention to kill or harm. It's something they had to do. So it's quite right. We were 8 women judges. They are dwindling all over the world. I've spoken to women judges all over the world. They say to me, well, I'm only the one female judge here, or only two, and we can't make a difference because we're in a minority. And I said to them, you can make a difference. All of us, wherever we are, if we see gender discrimination, we have to speak up about it and condemn it. So I know you're going to come to the rape decision. Yeah, I'll respond to that later. So that's the added value of women. And above all, how can you have justice, fair justice, when you exclude 50% of the qualified candidates because they are women?
Since you already addressed jurisprudence issues, I think we can move on to that issue also, and we would like to hear more about your role in elaborating cases of these tribunals, and your role also in the Akayesu case, if you could elaborate on that, please.
So this is a reference to the decision by the UN Tribunal for Rwanda, sitting in Arusha, that delivered the world's first decision criminalizing rape as a crime against humanity and as a crime of genocide. It's true that some of the Nuremberg trials and the Japanese War Crimes Tribunal just touched on the issue, but this is the Akayesu case, the first decision on it. I found, firstly, that in every conflict situation, women were treated as collateral damage. So if you happen to get gang raped, that's just collateral damage that happens in conflict. Or they are treated as trophies of war. Military journals encourage the soldiers to go and fight, and then you can have those women as your trophies. So that was the culture, and the importance of this case is to call it a war crime. And the superior officer can be charged for the crime even though he does not commit the crime of rape himself. But if he allowed it, did not prevent it, or even if he had ordered it, that's the evidence in the Akayesu case, he can be convicted of rape. I found that there was no commonly accepted definition of rape in international law. What is rape? We have all our national definitions. Most of the national definitions are what we call body part definition. There has to be penetration of the vagina by the penis. So in our court, the prosecutor kept asking witnesses who said they had witnessed gang rapes in this war situation. The prosecutor asked witnesses to say, well, did you see the male organ enter the female organ? And it was ludicrous in a war situation that the prosecutor was following national guidelines. So we created a new definition for international law, which has now been adopted in the Rome Statute, applied by some courts. It's true some countries already had a definition close to this, and that is a gender-neutral definition, because rape happened of little boys in former Yugoslavia. Put it closer. And the Yugoslav tribunal had charged sexual violence against boys and men, but not rape, because there was no such thing as raping a man. This definition is the physical invasion of a person of a sexual nature under coercive circumstances. And soon the court developed that because of coercive circumstances, it's a war situation, You cannot expect the prosecutor to prove that the woman didn't consent. So the courts have said that in a coercive situation, consent is irrelevant. So these are just great strides made in the International Criminal Tribunal, and I can truly assure you it made a difference, because it's only benches that had women in it who took up these cases and who understood the evidence given by witnesses.
Thank you. We would also like to know, because we're very curious about all of your work career, and we would like to know about what lessons you can share about fighting for equality in South Africa before and after apartheid. Just a few comments, if possible, as a woman lawyer.
Well, South Africa was a very unequal society under apartheid, so there was not only racial discrimination but gender discrimination. All women married in community of property, that's the law of the land, were minors subject to the guardianship of their men. And the parliament was obviously run by the Afrikaans men, and every time somebody tried to change the law to have women also as majors with power to contract and so on, unfortunately we didn't get the support of Afrikaans women, because they said that they wanted to remain as minors under their husbands. They did not want to hurt the feelings of their husbands. So that's a background to how difficult the situation was. And when we knew that President Mandela was going to be released from prison, it was the women who got together in a very broad women's national coalition. They were women from different points of view. They were freedom fighters. There were these Afrikaans women who wanted to remain as minors. There were different church groups. Of course, I respect church groups, yeah, but they were not too worried about women as long as they cleaned the church and so on. Even the church had separate roles for women. So the Women's National Coalition drew up a document, and the key concern was equality of women, equal opportunities, and removing this minority clause. So women have, because of equality, equal rights to contract. And I myself was a victim of this law, because my husband and I were in partnership as lawyers. And even though I worked harder and earned most of the money, it all went into his name, because under law only he could open the bank account. The house had to be in his name. So I can tell you from experience how it worked. So what the women drew up as their document actually ended up as the Bill of Rights in our Constitution. So small efforts such as this, collective efforts, are very important.
Thank you. I think we can talk about this for a long time, but we have such a short time here at this seminar, so I would like to go back to the GQUAL campaign and the gender parity question. Since you have had the opportunity to see the GQUAL statistics, I would like to know if you could share your thoughts about these figures, and also to comment on possible way forward.
Well, I am not part of the GQUAL campaign. Obviously, I've been asked to come and share thoughts with you, but I support that campaign. Those statistics are right, and that's not just the International Court or the ICJ, it's all over the world. Somehow they've accepted as normal, you put in a few women and then it'll be all right. So 2 is all right, 3 is all right. So we have to stress the principle of equality in this campaign, and not ask that, not find reasons why they should put in women, but ask questions on why they aren't there. And a good example is the key role they played in the Rwanda Tribunal and the Yugoslav Tribunal on, for the first time in the world, recognizing what happens to women in war as war crimes. I think that we have to do a lot to train women as judges, so they are more confident and are able, even if they're alone on the bench, they're able to make principled positions on equality of everyone. So that's a good campaign. I think all of us should campaign with our own governments, because they are the ones who get to nominate candidates both in the national justice system and the international justice system. So thank you for this campaign, and I hope you get lots of support here.
Thank you. You're very welcome to join us also for the campaign. Thank you.
Thank you.
Do you want to sign the declaration?
No, I don't want to be recruited by anyone. I play my own role from the outside, right? I get like 10 requests a day to join.